So welcome to Admitted Students Day. My name is Erin Braatz. I am one of the professors who teach the first year criminal law class here at Suffolk University. And the class I'm going to do today is a review of basic elements, which is either the first class you would have in a criminal law class or a review at the end of the class, however you want to view it. So before we begin, I want to ask, I want to situate criminal law within everything that we do in law school. Criminal law is just one of the many classes that you would take. You could also have civil procedure, torts, con law, or contracts. But criminal law itself could be divided in many ways. So first, let's think about what is criminal law, or what do you think about when you think about the criminal law? Yes, Ms. McCune.
I think about prosecutors and defense attorneys.
Okay, prosecutors and defense attorneys, so two of the essential participants in the criminal justice process. What else do we think about? Yes, Ms. Twynham.
The district and juvenile court systems.
All right, so different levels of courts that handle criminal cases, including typically we have juvenile cases treated separately from adult cases, for example. What else? Yes, Miss Lucy.
Like murder.
Murder.
Law and order.
Homicide. Murder is one that is typically one of the first answers I get when I ask this question. All right, so just to point out a few things that are probably floating around in popular culture, white-collar crime frequently comes up. Drugs, the drug trade comes up. Law and order. I mean, criminal law is a part of our popular culture in many ways. But what I want you to see by thinking about what you think about when you think about the criminal law is that what you are typically encountering in, say, a law and order episode is not necessarily everything that we're going to talk about in a criminal law class. So one way we can think about criminal law is by thinking about the substantive crimes that make up criminal law. So crimes against the person, that's your typical homicide case. Nobody brought up theft or robbery, but that would be crimes against property. And then we also have legislated crimes. Can somebody think of an example of a legislated crime? Something that's not a crime against the person or a crime against property. Yeah, Miss Lucy.
When you violate a statute, so like if you drive too fast?
Yep, so anything statutory like driving too fast. Other examples? Drug trade. Crimes against handguns or handgun usage. Sometimes this can be best understood historically. So in Massachusetts, one of the first crimes that was legislated, if we want to use the word legislated, when Massachusetts first became a colony, was that it was a crime to commit adultery. So we don't think about that anymore as a crime, but that's an example of something that is legislated by the legislature to be criminal for policy or social or moral, because of the moral values of the community. So this is one way of thinking about the criminal law, but this isn't actually what we spend most of our time in a criminal law class talking about. In a criminal law class, usually what professors are focusing on are the essential elements that make up any individual crime. So this shows you a lot of different crimes that could be committed, but the elements of those crimes are typically drawn from a limited set of elements that are present for any type of crime. And the three main ones that you'll spend most of your time talking about in a criminal law class are Actus Reyes, causation, and mens rea. So we're going to talk about what each of those elements are in a typical case. And we're going to start with the first one, Actus Reyes. So Actus Reyes is the physical part of the crime. That's the action element of the crime. The mens rea is the mental element of the crime. And when you put those together, so what is this person thinking as they are taking the action that then results in the harm that we would call the crime in this case? So let's think, so if Actus Reyes is the active part of the crime, what are some examples of non-actions? Because it seems almost intuitive that every crime has an action. So can you think of some cases where you wouldn't have an action at all? Yes, Ms. Foster.
Like if it's a reflex, so if like someone like touches you and you like I don't know, like when they hit your knee at the doctor's office and you kick your leg out.
Right,
Like, that's
and
a
you're
reflex.
startled. If somebody
Yes.
bumps into you and you're startled and you have a reflexive action. Sleepwalking or hypnosis would be other examples where you're acting not voluntarily. Notice that this is completely non-voluntary action. So a reflex is completely non-voluntary. Another example of a non-voluntary act, or another example of something that we're not quite sure what to do with under the action element, is failing to act. What about failing to act? Can you think of a situation where failing to act could be a crime? Yeah, Mr. Siegel.
If somebody had a legal duty to, in the course of their job or occupation to do something and they didn't do that, and because of that, somebody got injured or was killed, something like that.
Yeah, if you have a legal duty to act, then the failure to act could itself be a crime. Now let's think about that legal duty to act. What might that entail? So for example, if one of you is walking home and you pass an alleyway and you see a crime being committed and you just keep on walking, have you committed a crime? Miss Lucy is shaking her head. Why not?
No, because like was already stated, there's no, like as a passerby, you don't have that responsibility to act, versus if I was walking by and I was a police officer, well, it's my duty to protect the public.
So Miss Lucy has made a distinction between a regular passerby and a police officer. Why might we treat those two categories of people differently? Yeah, Miss Lucy.
Part of it is that if you put the responsibility on every passerby to help and to like if every passerby had the responsibility to help or to assist, then it would create the negative impact where no one would want to do anything and everyone would just stay home rather than risk going out and having the legal duty to go and like help in dangerous situations.
Does anybody think that there might be a moral problem with walking by, with observing somebody being harmed and not doing anything? Yeah, Mr. Siegel.
There's definitely a moral problem there, but in the grand scheme of things, it's kind of, like what Ms. Lucy was saying. There's a policy purpose there for not putting that legal duty on every single person to have that duty.
All right, so what you're seeing here is that criminal law is not always perfectly aligned with what we think is morally good or right. That in some situations, what is morally right isn't going to be what is criminalized in society for reasons that the legislature might choose. On the other hand, as Mr. Siegel pointed out earlier, there are certain situations where we do think that for policy reasons we will criminalize a failure to act, and that is when people have a legal duty to act. One example is a police officer who observes something happening, has a duty to intervene. There are a number of ways that duties can arise. We have statutory duties where the legislature decides to impose a duty. So for example, in Massachusetts, the legislature has actually passed a law that does impose a duty to report a crime if you observe one. So if you were walking home and observed somebody being harmed in an alley, you are not under a statutory duty to intervene, but you are under a statutory duty to call the police in that situation. Contractual duties can also impose a duty. An example of that would be, say, a restaurant owner who might have a contractual duty to help somebody who is choking in their restaurant, for example. Status relationships are a very common source of duties. A parent has a duty to help protect their child. Duties voluntarily assumed are, for example, back here, if you start to save the drowning person, then you've assumed the duty to continue on with trying to help the drowning person. You don't get to start out and then decide halfway there that actually you're going to abandon the effort. And then finally, we have creation of risk. If you create the risk, if you are a driver, for example, and you hit a pedestrian, then you are under a duty to help that pedestrian. You don't get to just drive away. I want you to focus on creation of risk because that arose in a case in Massachusetts from a few years ago called Commonwealth versus Carter. Does anybody remember this case? Does anybody want to tell me some of the some of what was going on in that case. Yeah, Ms. Foster.
So Michelle Carter was a high school student dating this guy, and and it was her boyfriend, whatever, and he was texting her about like potentially committing suicide, and I can't remember what specifically he was doing, but he was in his car committing suicide, and then he got out of the car, and she told him to get back in the car and continue what he was doing.
Excellent, Ms. Foster. You just summarized the facts exactly as I would. So in July 2014, Mr. Roy parked his truck in a secluded parking lot and set up his truck in such a way that he could pump carbon monoxide into it. Twice while he was in or around his truck, he had a lengthy phone call with Miss Carter. And subsequently, it was discovered through text messages that at one point Carter allegedly told Mr. Roy to get back into the truck. That's what Ms. Foster was suggesting. And a day later, Mr. Roy was found deceased in the truck. So this case was brought to trial in Massachusetts, and the trial court found that Carter's instruction created a life-threatening risk to Mr. Roy by putting him into that toxic environment, and thus imposed on Carter a duty to take reasonable steps to alleviate the risk. So you see what the trial court is doing right there. They're saying the Actus Reyes in this case was actually a failure to act. It was her failure to call 911 and say, hey, this person is in a truck and is in danger for his life. Could you please go find him and save him? It was that failure to act that constituted the Actus Reyes in this case. Now, this decision by the trial court was appealed all the way up to the Supreme Judicial Court, which is Massachusetts' highest court. And the SJC, the Supreme Judicial Court, agreed that Carter should be liable, but agreed on slightly different grounds. So the SJC found that Carter's constant pressuring and final command to get back in overwhelmed Roy's free will such that she was responsible for his getting back into the truck. So I want you to see that those are two different conceptions of Actus Reyes in this case. According to the trial court, the Actus Reyes was actually a failure to act. There wasn't activity on her part so much as a failure to intervene once he got back into the truck to commit suicide. The SJC, on the other part, found that her calling him repeatedly and texting him, and it wasn't just the telling him to get back into the truck, but their entire relationship was, they found she was trying to push him to commit suicide, that all of that pressure, that was action on her part, and that action was so significant that we could hold her legally accountable for pushing him to get back into the truck. So is there a question right there between those two conceptions of Actus Reyes at all? Okay, now what I want you to see is that with the SJC's conception of Actus Reyes, that her speaking to Mr. Roy was so significant that it overcame his free will and forced him to get back into the truck. Because keep in mind, where's Miss Carter during all this? Mr. Siegel.
She wasn't present with...
She's not, exactly. Thank you, Mr. Siegel. She's not there at all. So Mr. Roy is here with his truck and she's elsewhere. All of this is happening through her words, through her text messages to him and through talking to him on the phone. All right, so we have these two conceptions of Actus Reyes, and with the Supreme Judicial Court's conception of Actus Reyes, we have this problem of what do we do about speech acts? Because, as we just said, Michelle Carter was nowhere near where Mr. Roy was while he was committing suicide. And so we have to connect what she was doing at a great distance from Mr. Roy with what happened to Mr. Roy. And so taking us back to our three essential elements, I want you to see that is what connects Actus Reyes to causation. We need to figure out what is the causation here that can explain why Michelle Carter's words, that was the Actus Reyes up there, were such that we can say that they caused Mr. Roy's death. So, just to give you a brief introduction to causation, causation is what connects this action with this result. And there are two separate, I don't want to say the word elements because I'm using elements elsewhere, but two different portions of causation that have to both be found in order for there to be causation in a criminal case. The first is but for causation. But for the individual's actions, the bad result would not have occurred. But for causation is a very broad category. In fact, if I was to redo that slide, I would make this left circle much bigger than the one on the right. But for causation could even include but for the designer of the truck, of Mr. Roy's truck, designing the truck in such a way that he was able to find a way to redirect the carbon monoxide, he would not have died. Now that doesn't mean that we're going to hold the truck manufacturer criminally responsible for his death. It's just but for all of these different events, then Mr. Roy would not have died. So but for causation is fairly straightforward. Can somebody tell me how it's found in this case? Yeah, Ms. Foster.
But for the text messages, he might not have gone back into the car.
You have to be able to say that, but for Ms. Carter's text messages telling him to get back into the car, he would not have. So that's already something of a hurdle that the court had to overcome. But then the second one is what we call proximate causation. And that's showing a closer nexus between Ms. Carter's acts and Mr. Roy's behavior. And usually there are two components to proximate causation. One is we say that that a result is the natural and probable consequence of somebody's action. So is it a natural and probable consequence of a girlfriend telling her boyfriend to get back into a car that he would actually do that? And in order to find that, you have to know a little bit more about their relationship and the nature of their relationship. But then two is, were there any intervening actions that would break the proximate causation link? And in other states and other cases that have had a similar set of circumstances, where you have one individual encouraging another to commit suicide, typically what those courts find is that the free will of the individual committing suicide is the intervening action. So what the SJC had to find in order to say that Ms. Carter's words, the Actus Reyes, were sufficient to cause the bad result here, Mr. Roy's death, they had to find that her words were so persuasive or powerful within their relationship that it overcame Mr. Roy's free will. Otherwise, Mr. Roy's free will decision to get back in the car is the intervening event that would actually be the proximate cause of his death. You're nodding. Does anybody have any questions about proximate causation? The causation is the element that probably causes the most difficulty for criminal law students, but it comes up a lot in torts, so it's good to get your feet wet with it in criminal law. All right, so then finally, just to close the circle here, remember we have three elements. We have actus reus and causation. We also have mens rea, which is and that's the mental element. That's an element that students are probably most familiar with coming into criminal law, because mens rea has to do with the level of intentionality that you bring to committing the act. So for example, if you plot for weeks the downfall of your nemesis and then you carry out that plan, we think that that's a higher level of mens rea than, say, accidentally bumping into your nemesis such that he falls down the stairs and has a bad result. So in the Michelle Carter case, she was found guilty of involuntary manslaughter. And involuntary manslaughter is an unlawful homicide unintentionally caused by an act which constitutes such a disregard of probable harmful consequences to another as to constitute wanton or reckless conduct. Now, that's a lot of words, but essentially what it means is that the court found that Michelle Carter didn't necessarily intend for Mr. Roy to die. She just acted very recklessly with regard to whether or not he would live or die if he got back into the car. So that's one of the lower levels of manslaughter that we have in our system, but it can still result in time in prison. So that brings our three elements in a circle in one case. Are there any questions about how those three elements interact in this particular instance? Congratulations, you all are going to pass the bar. Thank you so much for coming, and if you do have any follow-up questions, don't hesitate to reach me. My contact information can be found on Suffolk's website. Thank you for coming.